being a criminal case, I always think like that.
They must stop.
Yes. My ladies, I continue appearing on behalf of the first and second appearance together with my colleague, Mr. Kadondana. As the court pleases, my lady.
May it please the court, my ladies, I appear for the third appellant in this matter, assisted by Mr. Christian.
My ladies, for the fourth appellant.
May it please the court, my ladies, I continue appearing on behalf of the fifth appellant.
Please, my ladies, I continue appearing on behalf of the sixth appellant.
As the court pleases, my ladies, I continue appearing for the respondent.
My lady, I have spoken to my colleagues and we agree, including Mr. Lirungwe, that there were two issues that yesterday, when I was thinking I was out of time, I did not address, but it will be unfair to him to raise them in the reply. We all agreed that I addressed them, the two issues,
Okay,
briefly. And
now you have 10 minutes.
yes,
Okay,
I will
Mr.
be
We
completing
will
that.
grant you that.
As the court pleases, I am indebted to court. The two issues, my lady, may I quickly ask the court to volume 1, volume 1, in particular count 32. It's actually 31, page 127.
Yes, Mr. Namcor.
You see, in an attempt by the state and the investigating officer to make out a case for fraud, you see under C, your ladyship's under C in the body of the charge. It said one of the misrepresentations was that the said 9 service stations were encumbered to the ministry. The usage of that phrase, encumbered. The first point is that term is not in the agreement between the ENECON and the Ministry of Defense. It is introduced by the state in the charge sheet and the investigating officer in contravention of the integration rule as far as law of evidence is concerned, parole evidence rule, your ladyship. But more problematic, apart from the concession by the investigating officer that there was no misrepresentation prior to the 15th of July, there was complete misunderstanding both by the state counsel with respect and the investigating officer as that term. They were not entitled to introduce a term that is not in the agreement between ENECON and Ministry of Defense, but their inclusion of that term offends the law, and I wish to hand up a judgment on that issue. Can I have the one that is highlighted? Sure. My lady, I hand up an extract from a judgment of Rain N.O. versus Fleischer, 1984, volume 4, SA 863. The good thing, my lady, is that this judgment was from the former appellate division in South Africa, and in terms of our case law, those judgments prior to 1990 of the former appellate division, unless upset by subsequent judgments in Namibia, are binding on Namibia. May I invite the court at the bottom of page 872, the court referring to Justice, Chief Justice Innes in a judgment delivered in early 19th century. The court said, and encumbrance means a real burden on the land, a portion of dominium parted with by the owner. If it does not mean any reference to the land in a contract, giving a mere action in personam into the contracting party with respect. What it means is that when you are talking in the context of to encumber, it's not personal contractual rights, even in relation to land. For instance, if you say, I am selling you my land and you are taking me to court for breach of contract, encumbrance means more than that. You part with in other words, you subject your right of dominion so that right is respected by not only by the party, by everybody. For instance, if you take out a bond, then the land is encumbered. My lady, it's not a personal contractual right. Therefore, to move to the last issue, first of all, the state case fall flat on the basis that encumbrance is an alien introduction by the state, a strange one, a curious one actually.
If you say the state's case is falling flat, you are meaning count 32 then?
Yes, on the fraud where they sought to introduce a term themselves, not appearing in the contract between ENECON and Ministry of Defense. But even if it appeared, it can only work if encumbrance in that respect meant the asset that were owned by ENECON were encumbered, so that right of the Ministry of Defense, as far as encumbrance is concerned, binds everybody. Your ladyship, you cannot go to the ministry and seek to get any right because there is a registered encumbrance of the right, my lady. So with respect, I think the state in panic to try and justify why people were arrested find itself laying its hands to any term they wanted close to their hands.
Are you saying it's a defect in the charge sheet?
It's because in law there are several legally speaking, it's an impossibility because the term is not in their contract.
Yes.
Parole evidence rule is against them. Integration rule is against them. Secondly, they, with respect, misunderstood and misconstrued what it means. Remember, in cross-examination, my colleague will have to defend his mispraised cross-examination of my client. He was saying that, these assets were encumbered because of 15 years. 15 years has nothing to do. It's a contractual personal right that my client must continue supplying Ministry of Defense, ENECON. It's a contractual personal right. And it was never disturbed because the understanding between Namcor and ENECON is that you continue getting product from us exclusively and supply Ministry of Defense, and we benefit because we have exclusivity. So simple, my lady. And the last one that
I want to pursue this.
Yes, my lady.
I've read the arguments by the respondent concerning the so-called defects, or if there are any defects in the charge sheet. He says that that's irrelevant.
That?
It would be irrelevant at this stage, at bail stage. Because remember, he referred to this words that the appellants have said about the charges, that they are weak, they are half-cooked, they are chaotic, they are pathetic. And he's saying that even if the charges are weak, they are half-cooked, chaotic, and pathetic, it does not affect the strength of the state's case, which is a bail consideration.
I didn't want to kill a case this morning so early, but I decided, because you asked the question, to do it just right now with reference to a case law.
Yes, because I need to pursue that. You are going to give him an opportunity. Of course, he's going to have his version, but now you are saying, no, it's a defect. This charge does not even stand up from anyway.
Yes.
But he says that's irrelevant.
Okay, let me, three big and very big, reasons why that will not fly. The first is that it's common cause, and we stated in the introduction of our heads of argument that on the appearance of on the 10th of July, the apparent complaint that the charges were not clear. It is there, it is on record, my lady. I think it is even in the typed up court proceedings. My lady, I will give you, when I reply, I'll give you a page number. That means that we wanted the state to put its house in order, which was seemingly not in order as far as the charges are concerned. And fairly so, remember, we engaged the state at the time of a bail application, the state having chosen to tell us that we will be opposing bail on the basis of these allegations. We say they are not clear. Go get an opportunity. Make sure when the bail application took place, I think it's a week or 2 weeks thereafter. And they were given that opportunity by a magistrate doing justice. Remember, we were saying we want bail application to be heard on a Monday. But the magistrate, to do justice between men and men, the magistrate gave them an opportunity, and they went to their offices, and we understood that we have done our work. These are the charges between the parties. On that basis, they are stopped from complaining. They must lay in the bed they made. They cannot escape on an apparent division. In the magistrate court, that was not the argument. In the magistrate court, they were not saying that, except the investigating officer who started telling us medical things that the prosecutor have to be called from sick leave. So that is the first reason. Fairness, we asked for particulars, and we were given particulars, and they are bound by the particular. The second reason is Unengu judgment. In the Unengu judgment, Justice Ndo, and he referred to, because its fairness extend to bail inquiry, particularly because it has something to do with liberty of an individual who is still presumed to be innocent. Said, if you give, we decide your case based on the charge before the High Court. Remember that case, the ratio decidande, one of the ratio is, can you dispose of a bail application with reference to the charge, if a charge is bad? In the High Court before Justice Ndo, which is binding and has never been upset, I represented Mr. Unengu, and we won basically on a charge of rape, because we stated that the allegations of a concept of rape in our law, the elements in the section 2, subsection 1 of the Combating of Rape Act are very clear that it is an insertion of any part in the vagina, in anus, and so forth. And the judge, though, made it clear. If the state simply went to court and told the complainant, say that we had sex, remember there is a Katuta judgment, my lady, again, I argued it before Justice Maritz and Justice Silungwe, where they said it's not enough in a rape matter for a judge, for a state to rely on allegations of sex, because that does not conform to the elements of the offense. So the state cannot cry, and there is an obstacle because the judgment of Ndo is against them. Were they lying to us when they say we have revised the charges? Here they are. We are entitled to rely on the charges and to stop them from running away in panic. They can't. They are bound. And the last one is then the judgment I said it will kill their case, is that we have, from 1990, the court, unlike before independence, relying more on positivism, its function is now more broader, both in trials and bail application. And it was stated in a very important judgment where a conviction was set aside just because the lawyer was incompetent. They didn't know how to cross-examine And some questions actually almost came close to some questions I saw in cross-examination before this magistrate, but I don't want to go there. The case is S versus Chabedi. It's 2004, volume 1, SACR 477.
Yes.
477, and my lady, for your comfort, this judgment was followed in this court in S versus Andima,
Oh, yeah.
2010, volume 2, page 477. Now, the court from paragraph D, and this is important, and it addressed Justice Christian questions on regarding my grounds yesterday, so that it says,
You said which paragraph?
from D to the bottom,
Okay.
in the present constitutional era, it is one of the functions of a court of appeal hearing a criminal appeal to inquire, here it's a bail inquiry, into the fairness of the trial and to ensure that the accused's rights to a fair trial is fulfilled. Particularly where, as in the present case, an irregularity appear ex facio. The right to a fair trial confirmed by that provision is broader than the list of specific rights paragraph A to J of subsection provide. It embraces a concept of substantive fairness, which is not to be equated with what might have passed muster in our criminal court before Constitution came into force. And then it referred to the other judgment where it was said, whether there has been any irregularity, in this case is a misdirection, it's the same thing, your ladyship, or illegality, that is a departure from the formality, rules and principles of procedure, according to which our law requires a criminal trial to be initiated or conducted. So in other words, my lady, to complete your question, if we ask before court, give us something more concise so that we prepare for bail inquiry, and the state with its muscles and with its resources and a battery, and in fact, I will not call it a battery of lawyers. There were so many prosecutors, some in the gallery when we met the state council. It was a forest of lawyers and police officers assisting the state in this case. So when they go and sit in a huge room and they frame the charges and say, here it is, how can they cry today that, no, Mr. Namanja may be correct, they are incompetent, but we will amend them. So you are lying to us, they can't. The last one is then set off. With the greatest respect, my lady, I continue asking, did we actually have court in the magistrate court? Court, a judicial tribunal, a judicial hearing, did we have? The big answer is that no, we actually did not have. If we had one that was not impartial and one that was not competent, with greatest respect. And competence is not, because there are people who come around listing PhD, whatever. I'm not talking about to tick it off that the magistrate have a law degree from UNAM, where I also studied. I'm talking about whether the magistrate was competent enough to discharge and undertake an inquiry such as this to dispense justice in accordance with the law, with no prejudices, my lady, to anyone, and no fear. My lady, Justice Christian, as a young acting judge, I had to take one of your judgment in a malicious prosecution to the Supreme Court in Mahupiro versus Mahupero, and you wrote a very good judgment on one point. It was your judgment that found in Namibia first that a prosecution can be legitimate from the beginning, but in between, from a certain date, when it becomes clear that there is no evidence against an accused person, the state has a duty to stop prosecution. That matter, that principle that you wrote about, did not was not upsetting the Supreme Court. The judgment was set aside, but that principle was confirmed. But you, at that point, you were an acting judge, but it was a high treason matter, where alleged republic interest people died in Katima. So a judge or a presiding officer must not be there to buy faces. So let's see how, with respect, if I was in a cooker shop, I would say the court we got was buying faces with respect. I want to take your ladyship to the findings of the court on set-off, where the court just took the investigating officers.
Is this your second point you are addressing?
Yeah, set-off, my lady.
Is it your second point
Yes,
you are addressing?
Yes, sir.
Okay.
And it's very important, my lady. Yes. It is in the judgment, my lady, if you go to paragraph 52 and 53 of the judgment, I think it's page 4688, if I am. Yeah, paragraph 52, my lady.
Yes.
And I don't like these labor arch files, they problem too. Paragraph 52 and 53, my lady. Yes.
So it's 466.
To start at
4688 and 4689.
Yes. Okay. My lady, you would see disclose now to ownership. That is from page. I'm looking for the paragraph, my lady, that spoke of the fact that he found that the Enecon paid with.
Enecon?
My colleague is.
It's paragraph 53.
Oh, yes. Yes, it's in the middle of 53. And it is many, let me just address it, how it doesn't even begin to fly. First of all, is a complete misunderstanding. The investigating officer thought it is inappropriate to ask him to say, look, you are investigating a matter that is in a commercial context. Were you ever trained on law of contract or commercial, just to have a rudimentary and basic knowledge so that you don't start running around just arresting people because you don't understand? It's not a bad question. We asked that question because in a commercial job. So now the judge said, the magistrate said, no, there was no payment. That is Namcor's money. Ignoring that the agreement was found, even him found that the agreement was legitimate. In some cases, the magistrate also found that the agreement had to be complied with, my lady, in some part of his judgment.
I'm not following. Are we now speaking about the 35 million?
Yes,
that
set-off, because it's basically a set-off.
Yes. Okay.
Remember, a set-off is, my lady, is, legally speaking, is when two parties to an agreement have mutual debts to one another.
Yes.
And the most important thing, and this is a case I want to refer to with the magistrate with respect, we didn't want to burden because we assumed the magistrate knows these basics, but I think we took a risk by not giving him the basics. May I hand up a judgment of union? Yes. Just hand up that copy. I cannot find some copy, but I can read it out and then hand up. It's a 1926 judgment, my lady. That case of Schroet versus Union government.
Yes.
And again, everybody who has gone to a good varsity, not in Afghanistan or wherever, but in South Africa, Namibia, good knows who is Chief Justice Innes. And at the bottom at page 289, Chief, that judgment says where it starts after England, my lady Justice Christian, I think you have the copy. It is a recognized principle of our common law, referring to set-off, my lady.
Yes.
When two parties are mutually indebted to each other, both debts being liquidated and fully due, then the doctrine of compensation comes into operation. The one debt extinguishes the other pro tanto, as effectually as if payment has been made. Should one of the creditors, then it goes on. The point is, then it goes on the other. Set-off happens as a matter of law. When you pay, you are just effectuating it. So in other words, what happens here, it was open to Namcor actually, if they wanted, because remember their legal department is the one that drafted the agreement. It was open to them to say, Namcor, you owe us over 53 million. We are buying interest title and so forth for 53 million. We could actually take everything. It was open to Namcor to say that. But the magistrate will not have a right to say, because it happens ex lege. It is nothing need to be said. If you owe me 20,000, I owe you 10,000. It's a question of law. So there is therefore no concept of the magistrate to say, Enecon paid with Namcor's money, because if they wanted Namcor, they could have taken the money and say, in terms of this agreement, the 53 million is due to you. We are not going to pay you. But because they want a relationship, remember Namcor was suffering from this commercial attachment issue, wanting to be after my client's good contract, want to be a future supplier to MOD. So they agreed that only 35 million. So it is wrong, given that. Whether it is an agreement, my lady, it is an agreement or not, by way of set-off, that 35 million would in any way have been paid to Namcor. And that is what I wanted to address. And my colleague, with respect, his submission misled the court altogether. We will not have been here. The accused person should never have been refused bail. Those are my submissions, my lady.
Thank you, Mr. Namanji.
My junior, I just show. Oh, very good. Yes. My junior is just referring me to page 148.
Yes. There are two issues that maybe so that we don't come back. The issue of 480 million is on top. Your ladyship, you can see that big number. That is on the first day we were hit with this 480. But at the bottom, when Mr. Namanja is my lady on the left-hand side, Yes.
you would see that from paragraph where we are talking about, we are going to be provided a complete indictment at 415. If you look at the record when we started bail application, we were never provided. We complained why the court order was not complied with. So the state provided itself with more time to work on the charges.
Yes.
An advocate from the High Court was placed, and a very good friend of mine, Advocate Rirongwe, was brought in to be with Advocate Hinda, so that the charges are proper, my lady. So the complaint is there. So, and I'm addressing the issue of Justice Christian to say, apparently in their heads are saying, yeah, let's not talk about that. They were given an opportunity to fix, and they promised court that they have fixed it, my lady. Those are my submissions.
Thank you, Mr. Namanji. Mr. Lilongwe. Oh, Mr. Simunye.
My apologies before my colleague Mr. Lidungwe takes the floor. I promised the court yesterday there's a case on the issue of the 14 days appeal from the magistrate court to the High Court. I did get the case. I beg leave to hand up the case. But it's basically, Your Ladyship's on, it's the case of Zacchaeus Cornelius versus the state, CA 103/2009. The appropriate section of that is page 5. It's on page 5. It starts on page 5, but going to page 6. But it's talking about helpful guidelines to judicial officers when explaining the right to appeal. So if Your Ladyship turn to page 6, on top of page 6, where it explains should lodge the notice of appeal with the clerk of the court within 14 days from the date of conviction and sentencing. So it's the issue of where the 14 days emanates from. So this case, the judgment delivered by Liebenberg and Tomasi J. Axel explained that issue of the 14 days.
But does it help us regarding the issue that was raised? Because it's the very aspect that we've spoken about. I think Mr. Casper is referring to a situation where Rule 67 deals with convicted accused persons, and this is what you are addressing.
Indeed
what is
so.
this judgment is addressing?
Yes,
now we are speaking about a bail appeal done in terms of Section 65 of the Criminal Procedure Act. His take was that Rule 67 should not apply because in this case you don't have accused that are convicted. You have somebody that has got a pending case against them who applied for bail, whose bail has been refused. And there is no rule, except for him highlighting Rule 51 of the Magistrates Court rules that deals with civil appeals, that says what the timeline is for a bail appeal to be filed. What we know is, that was his argument, is that bail is not civil, it's not criminal, it's in a class of its own. So if we use Rule 67, because it has been practiced, it will be 14 days. Then if you don't comply in filing the notice of appeal within 14 days, you should file an application for condonation. His take is, no, it would be best, because it's an application, that it be dealt with under the civil rules in the Magistrates Court Act. That is Rule 51, which will bring you to 21 days late. Then you can file a condonation.
Yes. But as Your Ladyship is saying,
yes,
in practice,
yes,
this has been adopted in practice. The 14 days emanates from there. For the sake of confirming where the 14-day period is coming from and having a case that is explaining that, it's for that reason that I brought up this case, where it's explaining the 14-day period.
Thank you.
May I please the court?
We'll consider it.
My lady, I don't want the court to look as if the court is now arguing this case on my behalf, and I would be remiss if I put you in that predicament.
Yes.
The simple point I made, and in fact this authority is not good proposition for the point I made. Number one, it deals with an instance of a convicted person, and it does not concern itself with a bail appeal. And in fact, where the 14 days are birthed in any event is again the misplaced reliance on Rule 67, Sub-Rule 1. But of course, for this instance, it's not misplaced because the court was then concerned with a convicted and sentenced individual. So, court, please.
Thank you.
Maybe while I'm on my feet, my lady, just one small aspect. And it speaks to the question you asked, because I get the impression that it troubles you, my lady, but in relation to the issue of the charges.
Yes.
Now, my lady, let's accept that's what the situation is. And then, in opposition to bail, the state says to the accused persons, amongst others, why we are opposing bail is because these are serious charges. And then, I mean, it's a strong case that the state has. How do you assess that reality, my ladies, if not on the charges before you?
I have a question for the respondent when he rises.
I'm sure you will.
A follow-up question coming from the question I've posed to Mr. Namanji. And then, when we reply, after he has addressed, I would want us to respond also to that follow-up question.
We look forward to that, my lady.
Yes.
The court, please.
Thank you. Mr. Lilongwe, Unless there's somebody else who wants to say something.
I hope not. I hope not, my lady. As the court pleases, my ladies.
Mr. Mulunga?
Yes, my lady.
I was just reminded it's just before 11, so we will break for tea at 11.
Yes.
But I want you to address us firstly before you start, because it's been raised here that the court gave you everybody an order to use the portal of the ancillary process on the case management system to bring your application for condonation.
Yes.
And yours were not brought through that process, although it was part of the court order, and I think it was explicitly part of the court order. So I want you, if we convene at 11:30, I want you first to just address that, because according to the objections that we received from the appellants, they indicated that they would not like you to then use your heads of arguments in this matter, because it's not properly before court.
At least just Mr. Kashivena. Yes, I hear that, my lady.
No, but I think it's the sentiments of court also, because we gave you an explicit order.
Yes, my lady.
So we would like to know, firstly, why we should hear you on your heads of argument in this matter, or why we should take cognizance of those heads of argument.
Yes, my lady.
Because they were not followed, they did not follow the process as set out by the court on our previous appearance.
Yes.
But the court stands down for tea. Yes, Mr. Mulunga.
Mr. Court, please, my ladies. My ladies, I got sight of the order that stated that we had to do, amongst others, to file the documents per the ancillary process. But my lady will take notice that for the past 3 weeks or so, the e-justice system has been having issues. And when I tried to do it via the ancillary process, unfortunately, I couldn't. Because even for my heads of arguments, which are about 52 pages, the system was failing. If I upload, it will show that it's loading, and then at some point it will say failed. So I had to redo it again. So when I tried to do it via the ancillary process, I couldn't. That's why I just then uploaded the affidavit, my affidavit, and the confirmatory affidavit.
But you also didn't file a notice of motion.
Pardon, my lady?
You also didn't file a notice of motion.
Indeed, my lady, I didn't file that. I think that was an oversight because when I wanted to do it via the ancillary process, I just thought, let me just file the affidavit and the heads of argument because I thought those were of more importance. Not that the ancillary process is not important, but yes, it was an oversight, and for that part, I humbly apologize.
George?
Yeah, I mean, if a scenario like that comes up,
Yes,
it's
my lady.
important that we file a status report for the benefit
Yes.
of all the parties,
Yes, my lady.
well in advance, before we would come to court.
Yes.
Our take on this is that because this is an important matter in which we are discussing important issues, we are going to to allow you to argue using the heads of arguments which are currently for the benefit of the court. So you may proceed and address us in this regard.
Thank you, my lady. I'm indebted to the court. My lady, before I start, is there a manner in which this court wants me to address it, or can I just proceed and deal with? Because the way I want to deal with my submission is that I want to respond first to what has been submitted before I get to what is in my heads of arguments.
Why don't you combine the process? Because remember,
Yes.
what you're going to address or respond to is what you have also addressed already in your heads of argument. So if you get to a particular point,
Yes.
you will just tell us, this is the response on this argument
Yes.
that was advanced by who,
Yes.
and I want to deal with that. But when you come to the issue of charges,
Yes.
I want you to take note of this question.
I think that's the issue I firstly want to start with, in fact.
Okay.
Yes.
So when you address me on that one, there was a matter of State versus Shilwani you've referred to concerning the charges.
Yes, my lady.
And you've relied on that matter, saying that the charges need only be sufficient for bail purposes.
Yes.
Based on the submissions by Mr. Namanje, the question that I've asked him, based on your further submission that the defects in the charge are irrelevant at the bail stage, that part of your reasoning, I want to ask, considering the submission that was made, your arguments on the issue of the defects in the charge that were raised, are you then conceding that some of the charges may need amendment before trial?
May even do, pardon me, my lady?
Are you conceding that some of the charges may need amendment before trial?
Yes, because there are still preliminary charges, but it doesn't mean that they are all defective. Because what we are saying, my lady, is that a bail application, unlike a trial, the accused person needs to know what he's being charged with, the dates, and the amounts are there. But what I've seen what counsel for the first and the second appellant takes issue with is just some technicalities that are there. Because even reference to the Unengu case, my lady, I've referenced it to on page, when the magistrate in the court Ako was writing his judgment, he made a distinction with regard to the Unengu case. In that, in the Unengu case, what is there is that the charges, in fact, were only amended, or not even amended, were only put at the stage of 119 plea. But unlike in the present case, that the charges at the commencement of the bail application, the charges were already there. But what he takes issue with is the fact that the charges are not proper. But if one looks at the Chilwane judgment, which I've referred to, in fact, I would like to give the court a copy of the judgment. In that case, which I find persuasive, it actually says during a bail application, the charges need not be full or contain full particulars, as long as the accused person understands what the charges are, and that was done. And I think, my lady, I have to put context with regard to this, because I think some of the information has not been put forth. Yes. Because during the appearance of the appellants in the magistrate's court, I think that issue was already canvassed by Mr. Namanje with regard to the fact that I do not want to take it as a fact that I'm hiding behind, but it's a fact that I was on sick leave, and we had to work through these charges in a space of 2 days to go through files, which were about 15 files at that moment. And I think counsel, whoever was involved in the bail application initially, would take note that we would go home around 3 o'clock in the morning, going through the charges. And then on the Monday morning, because we started on the Saturday, the Sunday, the Monday morning we were in court. So I'm just putting context to say 15 arch lever files in a space of 2 days, draft them, and then be in court. And then I'm also saying, my ladies, look at the Chilwane case, which I've referred to, which says, and I think I just need to emphasize something, a charge sheet as the stage...
Which paragraph?
Paragraph 40 on page 11.
Okay. You may proceed.
My lady, it says, a charge sheet at the stage of a bail application need not detail every aspect of the charge. It should at least inform the accused of the dates and places of the alleged offenses, the names of the complainant, and general particulars of each alleged offense. Now, my lady, when one looks at the charges, are the dates not mentioned? Surely they are. Is the place not mentioned? Definitely it is. The general particulars of the offense, which is misrepresentation when we have to take into account the charge of fraud, or if we look at the crime of corruption, that of receiving gratification, we are saying that was enough for them to have known what the charges were. In fact, a further submission on that aspect will be that they were not prejudiced because they were not asked to plea at all. So I'm saying, in fact, when one looks at the bail inquiry, this issue of the charges is the one that clouded the arena, because up until today, these charges are still being criticized. And my lady, I would want to invite the court also to take cognizance of the case that we have referred to on page 17 of our heads of arguments.
Page 17.
17, yes. At paragraph 9.2. It's a case of S versus Davids. In fact, the beauty of it is that me and Mr. Namanje did that case. And And the judge in that case, it was a trial case, but he says the primary focus of the court is to reach a just decision based on all available evidence, not to be influenced by legal technicalities. I want to emphasize that, to be influenced by legal technicalities, because we are saying this aspect of criticizing the charges is just trying to cling on the legal technicalities. But can one argue that at the stage of the bail application, the issue of whether the appellants were candidates of bail, was it sufficiently covered? Because, in fact, my lady will also notice from the record that apart from Mr. Namanji saying there are half-cooked charges, weak charges, Mr. Kaspa also gave the charges a nickname. In fact, if it was a child, it would be a child with many names. So we are saying that aspect of the charges should not cloud this court's judgment too, so as to say, well, because the charges were defective as it is being suggested, then therefore the appellants were prejudiced. No, because what we are dealing with is the fact whether the appellants are candidates of bail. And the charges as they are sufficient enough, the amounts are there, the distinction should be made with the Unengu case that has been referred to, because these cases are totally different from each other. And in fact, we are arguing that they should not even be a comparison there at all. On the aspect of the charges, I think those will be my submissions, my lady. Unless the court has a question, I want to move.
There was particular reference made to count 32 and the word that you have used, encumbered.
Yes.
Do you regard that as per the definition in the Shilwania case that you have referred to on paragraph 40?
Yes.
Is that word part of the general particulars? Is that what you're arguing?
Is it part of the general?
General particulars of the offense that is alleged in count 32.
Yes, because we are saying when the matter is ready for trial, we will still carefully look at the charges, even though at this stage, if the court finds that, as per the definition in the case of, I think it's the Rain NO, the case that was referred to by Mr.
Yes.
Namanje, if the court was to find that when one looks at the definition here, in this case of Rain,
Yes.
and the manner in which we have used it here,
Yes.
but it again goes to the aspect of technicality, because we are saying just the fact that the word encumbrance is there, does that fact alone render the charge defective? Because an accused or the accused, as we are saying, at least understood what the charges are, that aspect can be cured when we draft the charges. Because I think on that aspect also, in the Criminal Procedure Act,
Just a moment.
Yes, my lady.
Members of the public that just entered, I see you enter into a court with drinks in your hand. Can you please take it outside? This is not an appropriate place to drink your cool drinks. Please, there's two of you. Can you just take it out? Sorry. Sorry, you can continue.
Yes. Yes, my lady, I was about to address the court on the request for further particulars, which is a provision that is provided for in the Criminal Procedure Act. In this case, when the appellants appeared in the magistrate's court, they did not even rely on that provision to say, well, these charges are vague or whatever. That is not on record. But what appears is the fact that as soon as the bail application commenced, halfway through the bail application, then the charges were being criticized. But the question that needs to be answered is that counsel for the appellants had an opportunity to go through the charges. If their view at that stage was to the effect that the charges were wanting or were defective in some manner. Why was that not put to the court accord to say, well, Your Worship, we have looked at the charges, the manner in which they are drafted. We would want further particulars, or we want this aspect to be clarified. That was absolutely not done. But it was just an issue that was brought about as we commenced with the bail application. So we are saying this is just a technical issues that counsel for the appellant wants to rely on or to cling on.
It was further argued on this point that if you've looked at the perspective under which this word was explained and the impact it has on count 32, and the fact that you had enough opportunity to review the charges before the bail proceedings proceeded, that you are literally barred from bringing changes to the charges before trial. And that's why I asked you that question. Do you then concede that based on the interpretation given, the charges may be changed before trial? Yes.
I'm really sorry
Yes.
to do this. I did not say it's bad
Yeah.
to amend the charges
Yes.
before trial.
Yes.
We said for purposes of this appeal,
Okay. Okay.
they are barred or stopped
Okay.
from now,
Okay.
saying, because we asked them to revise them,
Yes.
and they did.
Yes.
But they can always change. But for purposes of this appeal,
Yes.
they are barred from and stopped from saying these were not our charges. Our charges are in future.
Thank you, Mr.
Yes, the
Namcor,
court.
for the clarification. Yes.
It's another issue.
Yes.
I've made arrangements to be assessed that I need to take leave of absence for an hour, my lady.
Mr. Casper, you excused?
It's
Yes.
court.
Mr. Lilingwe, it's clear to you now.
Yes, my lady, we are saying, because the question by the court is that we are barred from changing the charges, but I
For the
think that-
purposes of this application,
yes,
the charges are as they are in count 32, because we're speaking about count 32.
Yes, I agree. They are as they are because we cannot amend them for the purposes of this application, which is bail. Yes, they are.
And you are
as they-
saying that everything that is in that count 32, the particulars have been provided as stated in the matter of
Chilwane.
Shilwane,
Yes.
and it satisfies that requirement.
Yes, it satisfies that, except for the aspect of encumbered, which we are saying that is irrelevant because one word only cannot render the charge defective.
Thank you. Thank
Yes. So, my lady, on that aspect, we are saying the court should disregard this technical issue of saying the charges are defective. It's neither here or nor there because the charges are clear. The appellants understood what they were charged with. Now, my lady, there is also another aspect. I think I'll be going through the submissions as they were made. There is an aspect of the court not having relied on the expert evidence of Mr. Mulunga. I think he's the
you. Yes.
fourth
The expert
appellant
evidence
of the first appellant, second, and the fourth appellant.
Yes.
With regard to the aspect that they are experts in the fuel industry, as it was put. But, my ladies, my argument with regard to that, and I'll provide the court with a case, is that
Was it, I just want to, before you address me, clarify.
yes,
It was this issue of, there was expert evidence presented, and that evidence was not considered in the absence of, I don't know, is it contradicting?
Feasibility study by
Yes,
Shefeni and them.
Yes.
I wanted to say it's not about accused number 1, 2, and 4.
Exactly.
As I understood it, it was people
feas-
working for Namcor as well as outside consultants, SEAL, I think.
Yes, and the
Yeah.
feasibility study, as I
Yes.
argued yesterday,
Yes.
was then presented and relied on also by the state in the bail application That's where I then referred to Crown Security versus Gabriel.
So I did not understand it to be, and I think this is my sister's problem also.
Yes.
I did not understand it to be the expertise of accused number 1, 2, and appellants number 1, 2, and 4. I understood it to refer specifically the point that was raised with regards to the feasibility study.
But with regard to Mr. Mulunga, we did say it was ignored, but not as an expert. We just said his evidence was ignored on that aspect. But the crucial issue is the report by Namcor itself, by its own expert.
Yes. You may proceed.
My lady, I don't know whether it's appropriate for now, because it looks like I'm being interrupted as I'm submitting, because I think Mr. Namanje can...
Sorry, Mr. Mulunga, I'm going to interrupt you also. We'd just like to clarify
Yes.
that and this is where you can correct us, because this is what our understanding from the submission was, and you are applying to that submission. So if we are wrong, please correct us, but currently we have the understanding that the expertise only dealt with that report.
Yes. I'll just look at the... Yes, I'm getting it. I got it from the... It's either the notice of appeal itself or the heads of arguments.
For the first and second appellant.
Yes.
Page 57 of our heads of argument, paragraph 80.11.
Yes, you might proceed.
I'll proceed to another aspect. I think I'll get to this aspect later. Now, there is also an aspect of saying Enacon did not pay back the debt of Namcor with Namcor's own money. But if one looks carefully at the transactions they were done, because it is not in dispute that at first Namcor paid 53,212,000, and thereafter the money, the 35 million was paid back to Namcor for the date of the fuel that Enacon had owed Namcor. So I do not think it's wrong to argue that Enacon paid Namcor with Namcor's own money, because in fact the 35 million was not paid before the 53 million was paid. So by logical conclusion, in fact, to suggest that is not the argument, we are saying that argument slips through the fingers, because the evidence is quite clear that if the court takes in cognizance of the fact that before that there was the date of 73 million which was ceded by EcoFuel to Enacon. And that 73 million, as up until now, that 73 million has not been paid. But the 35 million which Enacon itself owed to Namcor was paid as soon as the money for the asset purchase agreement was paid. So we are saying, why not settle it before you get the 53 million? So the argument is therefore correct to say, in fact, Namcor was paid back with their own money.
What do you make of the provision of the contract that stipulates that it's the arrangement that the 35 million will be paid from the 53 million?
My lady, the beauty of these contracts is that sometimes fraud, as is in the present case, can be disguised in agreements. Because we are saying that clause in the asset purchase agreement was conveniently put there just for them to pay back the money.
But wasn't that clause included by Namcor? Because they were the drafters of the agreement?
Yes, because there are also charges of conspiracy. Hence, we are saying there was this offer to purchase the assets, because I think I need to take it further. Because from the beginning, the assets, and it's a concession that the first appellant actually made, that the assets were for the Ministry of Defense. He concedes, I can refer the court to the record, that whose assets, when I asked him whose assets were these, he said they were for the Ministry of Defense. So I'm saying, my ladies, that although it was put in the agreement or in the contract by Namcor, we are saying it was just conveniently put because there was this conspiracy to steal this money or to defraud Namcor. Because I'm inviting the court to have regard to the cancellation of the asset purchase agreement, which was authored by Mr. Shiwana Ndeunyema, which is on page 2705 of the record. 2705. Because we are saying, if this was a legitimate contract as it is being suggested, or a legitimate agreement, why would someone at Namcor, after the fourth appellant then leaves Namcor, then come and cancel the agreement? Because we are saying this was just a tool. It was just, even the clause was conveniently put there. The contract was conveniently drafted to include these clauses, because there was this conspiracy already to steal the money, the 53,212,000. Hence the cancellation.
You may proceed.
Yes, my lady, so in fact, it was suggested that the learned magistrate in the court was wrong to adopt what we had put to the first and the second appellant, that they sold a dream, that he should not have just adopted that because it's not supported by the evidence. In fact, today we are submitting that it's not just a dream that they sold. In fact, they sold them a nightmare, because up until now, that debt still haunts Namcor. That money has not been paid. So to suggest that, well, they did not sell a dream, it's absolutely not right, because we know for a fact that Enacon has been liquidated and Namcor has not been paid. I'm not aware, as I stand here, if that debt has been settled. So we are saying they sold them a dream.
Is that not a finding on the merits?
Pardon?
Rather than suitability for bail? Is that not a finding on the merits rather than suitability for bail?
Perhaps so. I'm just saying, because the magistrate is being criticized for buying the aspect of selling them a dream. So I'm just tying that to say, well, when one takes into account the law of property, which talks about the right of use, taking possession, or enjoyment of the property, none of these three was ever experienced by Namcor, which bought these fuel stations, or home-based fuel stations as they are called. Because if that is absent, then we are saying, yes, then there was a misrepresentation, because they did not deliver in terms of the contract, despite them having paid the money to Enacon.
So you are conceding that it's a finding on the merits rather than a suitability for bail?
Partly, my lady, because I'm saying if the court then accepts that the magistrate was wrong to adopt the concept of selling them a dream, then it should also accept our argument of saying they did not actually, they in fact sold them a dream. It's indeed true, because they did not take ownership, they did not take possession, they did not enjoy the use of this property. My lady, just on another aspect, slightly still on the asset purchase agreement. My lady will take note of the fact that there was an agreement, an initial agreement between the Ministry of Defense and Namcor,
Yes.
which at that time, at the time of the asset purchase agreement, the agreement was still enforceable. It was still in force. But
You see, this agreement that still had 9 years left.
yes,
Okay.
so we were being criticized in the court accord that, well, our understanding of the word discharge from the agreement is wrong. But I'm saying it's not wrong. If you are discharged from the agreement, it means you are excused. You are no longer part of the agreement. As per the agreement, as we have seen, and it's common cause that actually on record it says a certain Ms. Shivute actually complained when they got knowledge of the fact that Namcor had sold the assets without informing them. By them, I mean the Ministry of Defense. And also, again, still on that aspect, if we also take into account that Namcor still went ahead and cancelled the agreement, can we then therefore say this asset purchase agreement, despite the fact that it looks like a legitimate document, which we are saying, well, the legitimate part of it, well, to a certain extent, but we are saying it was the instrument that was used. So we are saying that was the genesis of the misrepresentation, because if they were not discharged from the agreement, they sell these assets, the Ministry of Defense complains, Namcor also goes ahead and cancels the agreement. What should the court then therefore make of that? We are saying there was misrepresentation. So to suggest that this was a commercial transaction which must have been dissolved in the civil case, that is not there. Because it was an attack on the charges, as we are saying. But I just want to put that aspect to rest, my ladies.
Just clarity.
Yes.
I just want to understand the argument is that what you are saying that the asset purchase agreement was used as a tool
Yes.
to combat the fraud.
Yes.
Okay.
As well as the corruption.
Okay.
Yes, as well as the corruption, my ladies. Now,
You might proceed.
I'll get back to the other aspect. There is this aspect of the magistrate being criticized of the fact that, well, all he said was, we are on record, we are on record. But I would like to invite the court to just want to get to the page. It actually relates to the exchange between the investigating officer and Mr. Casper. Unfortunately, he's not here. But that relates to the issue of him having told the investigating officer that he was talking nonsense. I know perhaps it might be said that it's not really an issue, but the magistrate is being criticized that he failed to control the hostile attitude of the investigating officer. But I'm saying, in fact, Mr. Casper was criticized and told that he must comply with the court decorum because the word nonsense, according to the magistrate in the court accord, did not comply with the court decorum. And also, there is another
Did that ruling address the issue that was raised?
Well, he just criticized him or reprimands him to say, well, you must be exemplary. I just need to get to the page because I have the page where he tells him that Mr. Casper, it's page 1893.
What was the gist of the complaint of Mr. Casper?
The gist of the complaint is that there was an aspect where the investigating officer testified that he was just there to oppose bail. I think that is premised upon that, in that the magistrate failed to reprimand the investigating officer or to
For being hostile.
For being hostile, yes.
Towards, yes.
Yes.
The questions that are posed.
Yes.
And the ruling you say, that you are referring to says he must please comply with the court decorum.
Oh no, is the court asking with regard to
Yes.
the reply of the investigating officer?
Okay, but now I'm asking.
Yes.
That ruling that you are referring to, did it address his complaint?
No, the ruling that I'm talking about relates to Mr. Casper saying the investigating officer must refrain from talking nonsense.
Yeah, but the issue that was raised, according
Yes.
to my understanding, is that the witness on numerous occasions, when prompted and asked questions, to respond to them, was hostile. And when they approached the presiding officer to address the, I won't say, for lack of a better word, I want to say behavior of the investigating officer for being hostile and not responding to the questions frankly as possible. What they got was that the judicial officer was referring to them and said they are on record. And the issue was about the hostility of the investigating officer. So what you are now pointing me is a scenario, one of the scenarios, where Mr. Casper stood up, although he used this word that you are referring to as nonsense, in his address regarding the hostility of the investigating officer, that your response is nonsense, and ask for the intervention of the presiding officer. What literally happened is that you are saying, he said, please stick to the decorum of the court. Is that ruling now not pointing to the manner in which the question or the complaint was raised? Or does it address his initial complaint of the hostility of the witness? That is the question.
Well, it does not, but it also was culminated by the fact that the cross-examiner was being argumentative with the witness. Hence the response. Because, my lady, if the court has regard to the record, it's only cross-examination of Mr. Casper and to a certain extent Mr. Namanje when it is being suggested that the investigating officer was hostile. But if the court has a look at the record, the cross-examination by Mr. Bangamavo, Ms. Gebhardt, I can't recall, but the other legal representatives of the appellants in the court ACO, that exchange of saying the investigating officer was hostile is not there. But it only became an issue because the investigating officer was, in my view, was being disrespected by counsel in the manner in which he was cross-examined. In fact, even on page 1897, when Mr. Casper was engaging with the court, in fact, the court cautioned Mr. Casper that can we have one speaker, because he was interruptive and argumentative with the court to an extent that the court had to adjourn. Or when he used the remarks, when the court cautioned him or told him, can you just be a bit slow? So he said, unfortunately, I'm not that slow. So I'm saying that conduct also was not just applied to the investigating officer, but even to the court. If anything, the court has to be recommended for having exercised restraint, although it didn't make sufficient rulings with regard to the manner in which the proceedings were conducted.
So your submission is that the presiding officer dealt with the
yes, he dealt with them, but not to a higher extent, because what he would say you should be exemplary. But he cautioned when he noticed that there was unbecoming behavior with regard to the league.
Mr. Mulunga, I just want to, as I understand it, the complaint is not with regard to the conduct or with regard to what happened. I think afterwards, the complaint is that something was pointed out to the court and the court did not make a ruling on that. It neither said, Mr. Namanje, you're correct, this witness is hostile, or Mr. Namanje, you're incorrect. I find no hostility with the witness. So that is how I understood the complaint to be. It's not because of the hostility of the witness, but because there was no outcome, call it outcome, for the objection raised. There was no decision by the court. It just said that it is noted on the record. And that is what I understood to be the complaint. Whether they were correct or incorrect, there was never a decision from the court to indicate to them there was a ruling on the objection.
Yes. So I understand. I think that is the way I've seen it on record also, because it was more neutral than a ruling to say this is the way I would want the proceedings to be conducted, because there is case law to the effect that the judicial officer must be in charge of the proceedings. But what I've seen, although he was in charge, the conduct of both Mr. Kasper and Mr. Namanje, unfortunately, even to a lesser extent, if the court finds that the investigating officer was hostile, that was not sufficiently dealt with. I'm in agreement.
Thank you.
I proceed?
Yes, my ladies, there is also an aspect of the arrest. It's not really an issue per se in bail, but I just want to invite the court to have regard to Section 21 and Section 28 of the Anti-Corruption Commission, Anti-Corruption Act. Sorry, my apologies. So we are saying, because one of the questions that is being suggested, or the submission being put forth, is that there was not a necessity to arrest. But when we have regard to Section 28, it empowers the Anti-Corruption Commission to arrest. So to say there was not a necessity of an arrest, that is the discretion that unfortunately, or fortunately in fact, lies with the Anti-Corruption Commission. So it is not for the prosecution or for counsel for the appellants to suggest that, well, in this instance it was not necessary to arrest, because the two sections, either you summon or 28, empowers you to arrest. And there was absolutely nothing wrong with the actions that were taken by the anti-corruption to arrest the appellants as it happened in this case.
Can you also respond just shortly to the, because on that aspect there were the principles laid down in the Hailulu judgment.
Yes.
Will you be able to respond to that as well? The issue of the non-invasive procedure to bring an accused person before court, considering the fact that there was evidence that they've cooperated from the beginning, when they were contacted, reached out. There was also that argument on that aspect.
Yes.
Unless you waive your reply.
No, I'm not waiving it.
Because you're not addressing it.
I just want to get to the section, the anti-corruption.
Was the act not referred to? It was in volume 9 of the...
Yes, it is, but I only have up to volume 4, so I'm just looking for the specific page so that I can refer the court to Yes, I see it's on page 2740. My lady, the section that we wish to rely on, we know we were referred to the Hailulu case, but we are still saying, although the Act empowers that aspect of summoning or bringing a person to court without necessarily arresting, but we invite the court to look at the provisions of Section 28, which says an authorized officer may, with or without a warrant, arrest any person whom he or she reasonably suspects that has committed or is about to commit an offense in this case. So,
but why should the general guidelines regarding arrest that was crystallized in this Hailulu case, why should that not be applicable also on arrests of the ACC? I don't see that they're exempted from those general guidelines. This section just gives them power to arrest.
Yes.
Because it also says may without a warrant.
Yes.
So why should this Hailulu case not apply on this type of arrests also?
My lady, it all boils down to the issue of discretion. We understand the Hailulu case is saying that, but what does the Act also say? Because they can either use that, and it's a discretion to use the two. So in this case, we are saying they exercise the discretion as they are empowered in terms of the Act to arrest. Although there is the Hailulu judgment, but the Act says may, with or without a warrant, arrest. And that would be our argument, that they use their discretion, which we say it was exercised properly to arrest instead of having to summon.
Let me further explore it.
Yes.
There was evidence that when the investigating officer was cross-examined on why he applied his discretion to arrest instead of using other means to bring them, the response was that investigations are at an advanced stage and it was now time to arrest. Can you respond to that? Is that what you say is the exercise of the discretion in this regard?
Yes, because, my lady, the thing is, in as much as counsel for the first and the second appellant cries foul with regard to the aspect of the arrest, but I am saying, did what the investigating officer do? Did he do it within the perimeters of the law, or did he do it outside the perimeters of the law? And we are saying, in terms of the Act and also in terms of the Criminal Procedure Act, he was empowered to do what he did. Perhaps just the answer is the one that creates ambiguity, but the answer is found in the Act itself, which says with or without, and you exercise a discretion, because there are cases, although not what happened in this case, in which a person is summoned by the anti-corruption, the ACC, Anti-Corruption Commission, or arrested. So we are saying it's either you apply both, but it's not cast in stone that you must always summon or you must always arrest. You use the two, with or without, you summon, and that's what we are arguing, my ladies.
Okay.
Yes.
You might proceed.
My ladies, before I forget, I just want to get to the aspect of the the third, I think is Mr. Leo Stefanas Nandaho, with regard to whether or not he was a member of Irongo Petroleum CC at the time the 500,000 was paid. I just want to invite the court if the court can just bear with me.
The dispute raised regarding his membership, or was it the issue of he was a member, but there were 3 signatories?
Yes, but I just wanted to invite the court to page 369. Because that contains the affidavit of the appellant.
Yes.
And importantly, he says during December 2022, and I'm reading at paragraph 44,
Yes.
He says during December 2022 until May 2023, the members and authorized signatories of the bank account of Irongo were me, Matthew Spendukeni Yambo, Christina Kambodi, Ndafenongo. But he says he was a 100% shareholder, which we agree, and we are going to refer the court to the amended founding statement, which is on page 3725. And because he says there, the state's allegation that during the said period there was a 100% shareholder is incorrect. But I want to invite the court to look at just want to make sure.
See, this issue of the typographical error, that was, because I want the context, so that when you argue, I know you are responding to issues or submissions that were made. Remember the calculation that brought us to 101, 110,
105, 103.
or 105, yes.
So we can't calculate.
105. Is it the aspect you are now speaking to?
Yes.
The 25 and a 30%.
Where is, yes, said in the one statement 25 and at another place 30.
Not necessarily that, because he's saying he was not 100% shareholder, but the founding statement here actually confirms that he was indeed 100% shareholder, because he's saying.
What is the page number of the founding statement?
Just want to.
Can you just give it?
725.
I think I was at the wrong one. Pardon me.
Amended founding statement.
This one is on page 3725.
Yes.
And if one looks at page 3727, it confirms that he was 100% shareholder there. So to say he was not, and this statement is dated, the date it was signed was 12 May 2022. And the date of change there indicates that it's 10 May 2022. And then, even if one goes to the one on page, another amended founding statement, which is on page 3729. It also still shows that Leo Nandaho Stefanas was still the 100% shareholder, and that is, to confirm that, is on page 3731. And then the one that suggests or that states that Austin Elindi became a 75% shareholder and the appellant a 25% shareholder is on page 3738. So I'm putting this in context, my lady, to say the documents, the amended founding statement actually confirms because the Austin Elindi only became a member in 2023. So we are saying the transaction of 500,000 that relates to Panduleni farming was done on the 17th of December. And on the affidavit on page 3690, paragraph 44, if one looks at the period, December 2022 to May 2023, we are saying the appellant was a member of this entity, although he disputes, but the documents speak for themselves. And we are saying that when the 500,000 was paid from Irongo, I think, to Quality Meat Supplies and then to Panduleni Farming, he was a member. And
He was a sole member.
yes, he was a sole member, in fact. Thank you for the word, my lady. So he was 100% member, and the court, we invite the court to look at the documents, because this Austin Elindi only comes later, sometime around 2023. And we are saying, despite the power of attorney, because he talks about the power of attorney, I just want to get, I think it's on the next page. It's actually on the same page, 3690. He says, during my tenure, I think this was an aspect that was canvassed by Mr. Kajivena, which says he did not play any role. But the argument can be as follows. So, someone, or the appellant in this case, is 100% shareholder or member of an entity, but then he gives someone else that is not part of the entity to be a signatory to the account. We find that quite implausible, or it raises an eyebrow. Why would someone that is not a member of the CC have signatory rights? We are saying, although that document is there, the court should not place any reliance on it, because we are saying paragraph 44 of the affidavit and the amended founding statement, which is at page 3725, actually confirms that he was a member. So at the time when the money, the 500,000, was paid to Panduleni Farming, he was indeed a member, and we invite the court that it should carefully look at the documents and the allegations that he makes in the amended founding statement. Yes. My lady, there is also another aspect which I want to look at, or which I want to address. It relates to fifth appellant, which is Ms. Olivia Dunaiski, which talks about the fact that there was only a $10,000 that she received from Venus Technology into her personal account. But we invite the court to take cognizance of the following. Firstly, Ms. Dunaiski was the commercial manager, number one, at Namcor. Number two, she was a member of the credit committee, which amongst others was responsible for approving the credit limit that can be advanced to a customer. And thirdly, there is a letter that she authored, if I'm not mistaken, is on the 8th of July 2022, which spoke about the asset acquisition, and it relates to the asset purchase agreement, because...
Is it the recommendation that she's made?
Yes, the recommendation.
That was approved by
Mr.
Mr.
Mulunga.
Willemse before it went to the...
Yes, it was
Out.
approved by Mr. Willemse, then it went to the MD.
Yes.
Yes.
Okay.
My lady, we submit that in terms of the Anti-Corruption Act, I'll get to the 10,000 first. Gratification can be created for yourself or on behalf of another person. But when we look at the case as it is, yes, we are saying there is only 10,000 that we can see from the bank statement of the appellant. But the fact that she signed these documents, firstly approving the sale, the asset purchase agreement, and also in fact signing and recommending, one should not look in isolation just to think of the 10,000 that she receives, but one should also consider the aspect of the 53,212,000, which is an amount that Namcor lost as a result of her approving these documents. And also, when I get to the sixth appellant, I'm inviting the court to take cognizance of the fact that even the fourth appellant, Mr. Mulunga, this asset takeover of the 9 home-based fuel stations were not approved by the board. In fact, when I get to him, when I address that aspect, he could not produce any document to say this was board approved, despite the schedule of authority, which talks about assets above 25 million have to get board approval. But let me get back to Ms. Dunaiski. I'm saying that aspect alone of the 10,000 should not just be the issue that the court looks at, but it must look at the genesis of these transactions, the 10,000 that she received. I want to move on to the
Please, you can continue.
Yes, I want to move on to the aspect of Mr. Mulunga. I believe he's the fourth appellant. My lady, there is this aspect that relates to the fact that there is no money that was received into the bank account of Mr. Mulunga. But I want to start my argument as follows with regard to Mr. Mulunga. Here is Mr. Mulunga. He is the managing director of Namcor. He is the overall person that has authority over the whole entity. In fact, even the transaction of the asset acquisition have to go through him before it's approved by the Executive for Finance and Administration. But I'm inviting the court to have regard to the offer. I'll just give the court the correct page. The offer that came from Namcor to acquire the assets of Enacon. And also to take into account the schedule of authority, which the schedule of authority, my lady, is on page 3528. But importantly, the issue of the asset takeover is on page 3541, which actually, the title there is Procurement of Goods and Services, and in brackets, as per board approved operational budget. and he talks about above 25 million goods, Central Procurement Board, or the board, as we have suggested. So, during cross-examination of Mr. Mulunga, he was asked that, well, for you to acquire the assets, by you, I'm referring to Namcor, to acquire the assets of Enacon, did you comply with the schedule of authority? He then says, well, there was also a budget of development budget, as he called it. But I asked the appellant in cross-examination, and that is on page 1130, with regard to whether he could provide any documentation that there was also a business development budget. But unfortunately, that was not there. He did not provide, and up until now, that document is not there that shows that these assets were part of the business development budget. And also, the fact that he could not provide any documentation of any kind, of any sort, with regard to whether he got the board approval to acquire assets above 25 million as per the schedule of authority. That, unfortunately, is not there. So, that's what we are saying. On his part, there is the aspect of misrepresentation, because he misrepresented to Namcor that he had authority. He is talking about the development budget, but unfortunately that is not there. And also, by extension, we are saying the court should also consider the fact that Shiwana and Onyema, I have touched on this aspect already, actually canceled the agreement sometime in September, should be September 2023. The cancellation, as I've already submitted, is on page 2705. So, as a result of his misrepresentation, we are saying he was the genesis of this whole misrepresentation, that Namcor lost the 53,212,000. And the court should not just look at the fact that, well, there is no money in his bank account, because misrepresentation can manifest itself in different ways. And him relying on documents that are not there, he misrepresented to Namcor, his entity that he was working for. My ladies, let me get to the aspect which was dealt with by, I think it's Mr. Kasper and Mr. Isaacs for the fourth and fifth appellant. This issue of the learned magistrate having applied a blanket approach, as it is called, and that would tie in with the aspect of public interest or the interest of the administration of justice.
You are discussing these two together.
Yes. So, my lady, I'm submitting that the appellants, as they are in court, did not operate in isolation, because we are saying they operated like a syndicate. Even the flow of the money shows so, because when money comes from one entity, it goes to another entity, and then it finds its way to the accounts of an individual or so. For instance, the aspect of the asset purchase agreement. In fact, the 53 million was paid on the 18th of July 2022. But if the court takes the totality of the evidence and looks at the flow of the money on the next day thereafter, on the 19th of July, for instance, the money that was sent to Onyeka CC, which is an entity which was owned, if I'm not mistaken, by the second appellant, in which the first and the second appellant got an amount of 1,500,000 each. And although he's not part of this application, but I just want to lay context, Mr. Willemse, 960,000 to his personal account, 1,040,000 to an entity that he owns, Parkwood Petroleum and Logistics. So we are saying it is that argument of saying the magistrate applied a blanket approach is not absolutely true, because if one looks at the judgment of the court a call, which shows that he actually analyzed the evidence from page 4702 of the bundle. I do not know in which one, but the page is 4702, in which he lays down the involvement of each particular appellant, their involvement, the amount that they got. In fact, he breaks it down on page 4703.
Yes.
Yes. And he goes on further to state this entity got this specific amount, this person got this specific amount, and their involvement.
You are referring to paragraph 74, no?
Yes.
Okay.
And then also paragraph 75, the court will see there that he breaks down the amounts as they were received to each specific individual or entity, and then reaches at the decision that he arrived. My lady, the aspect that was dealt with by Mr. Isaacs, which I want to touch on, is the issue of public interest or the interest of the administration of justice.
Before you go,
Yes, my lady.
the blanket approach was
Yes.
also referred to concerning the manner or the way in which the grounds of objection were dealt with concerning the individual appellants.
Yes.
Can you speak to that?
That the grounds did not particularize that in respect of this appellant we are denying bail because of this aspect. Is that what the court is asking?
Yes, that particular findings on the different grounds, considering the fact that there are different charges and some accused persons are facing probably 2 or 3 and others more charges, and also regarding the personal circumstances, I think, of some of the appellants that were not addressed properly. It was like a conflated finding concerning all the appellants on particular grounds of appeal. I think the blanket approach also addressed that issue.
Yes.
Will you be able to address us on that? Says that the court did not sufficiently consider the individual cases of the appellants as was presented.
Yes. My lady, the difficulty around that, or what I've seen from the judgment of the court is that this appellant appeared at the same time. It was a bail application that was done at the same time, and hence we submitted when I started that they did not operate in isolation. And I think that's why the argument is being stated that it was a blanket approach. But I'm saying each one of them ate from the same cake, and hence the magistrate then therefore analyzed the evidence in its totality, and he individualized, as I've stated on paragraph 74 and 75. That so-called blanket approach is from the premise that it's a syndicate type of crime, and he considered the evidence in its totality at once. Because although he does not explicitly say, in respect of this person, I've considered this, but in the summary, he shows that this particular individual received this amount of money, and towards the end, then he then makes the finding that he has considered the evidence in its totality. I think I'm just want to make context with regard to the specific page. It's on page 4730, at paragraph 112. I just do not know the line, but there is the part where it says, there is no doubt that the charges preferred against the applicants are of a serious nature, and it is also common cause that the parties entered into an APA, which is the Asset Purchase Agreement, and a payment in the amount of 53,212,000 was made. And he goes on. So we are saying, on the other page, which I've stated, where he starts to analyze, he looks at the transactions, and towards the end, then he makes the finding with regard to the charges. So we are saying the so-called blanket approach, as it is being suggested, is premised upon the fact that these people were jointly charged, and the flow of the money emanates from, for instance, the asset purchase agreement, from one single transaction which flows onto the other one.
What is your understanding of the blanket approach? And I'm going to tell you after you respond why I'm asking that question.
To apply a same
in the context that it
same
was
ruling
raised, of course,
to every other person without considering them individually. That was what I will understand by the blanket
so
approach.
to apply the same ruling with respect to all the accused together. What are you saying? I don't know. You must tell me.
It's not entirely a blanket approach, my lady. I'm saying when one looks at the fact that the individual transactions or the involvement of the money that was received, when the magistrate talks about this person received this amount, this person received this amount, and he comes to the conclusion that I've found that the applicant faced serious charges, we are saying he individualized in the first place, and towards the end, then he states the reason why he has arrived so. So it's not completely a blanket approach as it is being suggested. It was singled out with regard to the transactions. But I think the only problem that I've seen is the fact that the magistrate towards the end, which I do not think should be a problem, is that the applicants, without having necessarily referred to them individually. But that fact alone is not a fact that would suggest that it's a blanket approach per se.
Yeah, the reason why I've asked the question, I should probably give you the context, is because my understanding from what you have submitted about how you understand the blanket approach is that because they were charged together, they ate from the same cake.
They could be approached.
Yes, they could be approached. Yes, at the same time, and if that is your argument, I have two questions. When you drafted your your grounds of your arguments, you've individually referred to the appellant's cases.
When I addressed in the heads, yes, I did that.
Okay.
I addressed the the notices of appeal per individual, I did not generalize.
Okay.
Yes.
So, and that was clearly not evident from this blanket approach that is referred to here. If you really look at the ruling, because your submission, on the other hand, also literally suggested us sitting here, this court that has to determine this appeal, because they came together here and they're sitting together here. This appeal has been scheduled to be here on the same date. We can hear it together. There's no need for us to speak to the cases of the individual accused persons. Is that what I understand from your argument? Because there are legal principles outlined as to how, in the event that there's more than one accused person that applies or that is charged together, applies for bail, how the issue should be canvassed. And the legal principle is clear in our law, is that individual attention should be given to each and every person that comes before court. You are referring to aspects. If we go to your paragraph 74 and 75 on page 4702 and 4703, where literally the quote unquote goes to give us an indication of how the flow of the money went according to his assessment of the evidence that was presented before him. You are arguing that that is indicative of the fact that he did not apply a blanket approach, but he individually addressed the transactions. And that is not what we are talking about. We're here talking about each appellant who came, said that they want to apply for bail or that they want bail. The state is objecting. Grounds are raised for this objection. They bring their case forward to indicate why they shouldn't be, why they are candidates for bail. And the ruling comes forward, and you would have expected in the ruling. And this is clear from what we are having here, because if I now point you to what is the finding of the quo quo regarding the first appellant on all the grounds of objection, what is the finding regarding the quo quo on the grounds of objection raised in respect of the second, third, fourth, fifth, and sixth appellant? You should be able to point that to me in the record, and the record testifies, or the judgment, of what has been done in court. It's the record that is there available. So that's why I asked you the understanding of the blanket approach. How do you understand it? Do you see it as if there is an explanation giving about the flow of transactions, specifically where the money went from when it was paid in or paid over, that is sufficient for the court to be able to make a ruling that all appellants will not be granted bail on the aspect of public interest and so on? I gave you a long submission. If you don't understand it, please ask me. I'm willing to clarify it.
Yes,
but I wanted to bring context so that I give you a fair opportunity to address me on that, because it's a critical aspect that I need to consider, or that we need to consider when we are ruling on this matter.
My lady, I'll respond by referring to the court to what I've stated on page 3 of my heads, which I make reference to Section 65(4) of the Criminal Procedure Act, which is the court is well aware of, which says the court or judge hearing the appeal shall not set aside the decision against which an appeal is brought unless the court or judge is satisfied that the decision was wrong. So in my view, I'm saying, relying on this, and if one looks at the judgment of the court if the court was to find that there is a misdirection with regard to that aspect, is the misdirection so grave or so big so as to set aside the decision of the court accord. I'm submitting, my lady, that the court accord did not just say bail is denied in respect of all the appellants, but at least to an extent it individualized the payments and therefore came to the conclusion that, well, this is what I've looked at and this is why I'm denying bail. So we are saying, on the basis of section 65(4), the court should have regard to that section, that it should not just set aside that decision unless it finds that the mistake is so grave or is the magistrate materially misdirected himself. And that's what we are saying, my lady.
Okay.
Yes.
Thank you, Mr. Living.
May I continue? I see it's...
1 o'clock.
Is it 1 o'clock?
Yes. Shall we stand down for lunch? Yes, how long will you still be with your submission?
Maybe just 15 minutes maybe.
Okay.
Then I'll conclude. Because I just want to get to the sixth applicant with regard to her personal circumstances.
Okay.
That were...
You can continue.
Yes. So, my ladies, with regard to the sixth applicant, what is of importance is the aspect of her having 3 children. And in my head, I've referred the court to the case of Hoibeb on page 42 of our heads,
Yes.
which it was a case, a criminal trial actually, but what is of importance that I've quoted there is what I've underlined. It says, this is one of the consequences of crime and usually brings about more hardship to innocent person than what is hoped for. And what I've not underlined, it goes on to further say, unfortunately, one cannot allow one's sympathy for the accused family to deter one from imposing the kind of sentence dictated by the interests of justice and society. So, my ladies, I'm saying, we understand the circumstances of the sixth appellant with regard to the fact that she has minor children, but there are countless of other people who are in custody who have children. And if the court was to lean on this leniently, that, well, the appellant or the person that is in custody has children or there's a child, then therefore they should be granted bail. I think there will be a travesty of justice to allow each and every other person that comes to court and say, I have dependents, I have 10 children or I have 5, then you get bail. Because
isn't that a requirement in terms of the Child Care and Protection Act?
Yes.
That when we act, any state institution or any institution for that matter, we must always, when we do so act, we should act in the best interest of the child. Isn't that something that should have been considered, taken into account that it's a requirement in terms of that act, and it brings it in line with our international obligations that we also ceded to? That whenever we act as an instrument of state, we must take into account that such action should be in the best interest of the child. I know that wasn't argued by Mr. Simunye, but that is the applicable principles in terms of that act.
Yes. My lady, there is an aspect in the constitution of fair trial, and I think I'll just extend it to a certain extent to say fair trial does not only mean fairness to the accused, but also fairness to the victims of crime. So the gist of my argument is to say, well, we understand there is that act, but what the court has to do is to strike a balancing act. Unfortunately, sometimes the scales of justice do not balance. We are saying there is the welfare officers or Minister of Gender, Equality and Child Welfare, if I'm not mistaken with regard to the name. But we are saying the fact that that act is there And as I've already stated, my lady, I'm saying there are countless of other people who are in custody as we speak, who have dependents. In fact, some of them have been in custody longer than the appellant. But should that fact alone sway the court also to believe that, well, because you have dependents, then you should therefore be a candidate of bail? There are other factors to be looked at. And in this case, the seriousness of the offense as one of our grounds. So on page 1314 of the record, the appellant, when she testified that these children are in the care of the nanny. We understand that children, of course, require parental love, but that would not mean that they would not grow up. Unfortunately, one would still grow. With or without a parent, often still grow up. Although that aspect of motherly love or fatherly love will be absent, but we are saying that does not interrupt your growth. It will just have that thing of not having motherly love or fatherly love. But that fact alone, that the appellant has a minor child, that aspect alone should not sway the court. And also, the aspect of the 53,212,000, we look at the involvement of the appellant. I will conclude, my lady. Remember, there were two accounts, the 848 account and the 520 account of Enacon. And the appellant had access to the 520 account, in which money that was being paid was supposed to be paid over to Namcor. But then, during the bail application, it was clear that although the appellant was a signatory to the 520 account, no money was actually, let me not say no money, little money was coming into that account, which was supposed to oversee, rather, that the money is being paid to Enacon. In fact, during cross-examination, I put it to her that, don't you think Enacon played you, despite the fact that they made you a signatory to this account? You were supposed to see that money was being paid into this account, and then, despite that there was no money, why didn't you alert Namcor that this...
Just a moment.
Yes.
Wasn't the 35 million transferred from this account back to Namcor?
Yes, it was, but just a once-off. But when the court takes cognizance of the fact that there was... she was made a signatory to the account in 2021. But despite her being a signatory to the account, Enacon actually incurred this debt of 35 million, which was above their credit limit. So we are saying, if she was made a signatory to oversee, or what was she overseeing? If these people that had a credit limit, she's a signatory to their account, they are not paid. Why didn't she alert management that, look, Enacon is owing, then therefore, as per the credit limit, which says if a customer has exceeded their credit limit, we should cut them off from further supply of fuel. Unfortunately, that was not done. So that's why we are saying, because of that, that's why she facilitated the asset purchase agreement, because she connived with these people. By these people, I mean the people of Enacon. And also, just before I forget, it was suggested that there was no money that was received into her personal account. Yes, there was no money, but there is a property that she co-owns with her husband, which is in Dorado Park, in which an amount of 643,000 was paid towards her mortgage bond. A property, and I want to emphasize that she co-owns with her husband. So one does not necessarily need to benefit directly that the money be paid into your account. Because firstly, just for context, no board approval, signatory to the 520 account, money is paid, it is used to settle the mortgage, part of the mortgage of the house, and part of the money, in fact, some of the money that came into the because there was a total of 4,470,000. Part of that money again was used to pay the Agribank loan. So we are saying the court should not just look at the fact that, look, there is only the appellant did not benefit directly because no money was paid into the account. We are inviting the court to look at the fact that indirectly, because of a conduct of approving this money, she benefited indirectly. The money paid her mortgage bond and also the Agribank loan. Yes. The issue of public interest, my lady, I just want to conclude. The court is well aware of the cost.
Before you move there,
Yes.
you are saying in your heads of argument, I'm now at page 42.
42.
I'm taking you back to this argument of the consequences of crime.
Yes.
You are saying the sentiments expressed above were stated in sentencing proceedings in a criminal trial. However, they equally find application in the present case.
Yes.
That's your submission. On the one side.
Yes.
Then, on this side, we have the presumption of innocence of a person that is not convicted.
I take cognizance of the fact that she has not been found guilty, but I'm just.
So how do we borrow that principle over here in this bail proceedings and rely on it to say it's the consequences of crime?
Yes. There is also the other judgments of Wembodiga. If the court is not swayed by that Hoibeb case, there is the other on the same page. Wembodiga, I think it says the inevitable consequence of human nature is that children grow up whether their parents are incarcerated or not. If the court finds that my submissions of relying on the Hoibeb case is not persuasive, I am relying on a bail case where the appellant in that case was in custody, and the court expressed itself in the manner that it did, that children grow up whether with the parents or not, whether they're incarcerated or not. In fact, much reliance
Well, I'm
is
asking you
now
is because you are
placed on
telling
the
the court
Bodiga.
to impose that sentence, the WESEP principle, on this bail appeal.
in
Is
hindsight.
what you are requesting. So I'm
No,
saying, yes, because you are saying it's applicable. I must consider it because WESEP is applicable now currently.
No, I withdraw that submission. I'm relying on the Wembodiga because, you see, my lady, I'm saying, it just was put there to bring context. But the underlying principle is in Wembodiga, which says the inevitable consequence of being in custody, children grow up with or without a parent. That was just put there for context, but the Wembodiga, which was actually a bail appeal, speaks to that aspect.
You might proceed.
Just to conclude, the issue of public interest, as stated by Mr. Isaacs yesterday, it's a term that I've found that, if I may, nobody really knows what it is, but it's there. I would actually liken it to the issue of substantial and compelling circumstances in rape matters, in that it's not clearly defined what substantial and compelling circumstances, as well as the interest of justice. In fact, the cases that I've seen, the Gustavo case and the Ngipunya case. The Ngipunya case was before the Gustavo case, which the Gustavo case is actually a Supreme Court case. And the Ngipunya case is a High Court case. But what I've seen there is that, especially in the Gustavo case, the judges there in the Gustavo case says the interest of justice is difficult to define, and it's a phantom, which actually translates into it's a difficult thing to define. And up until now, the discretion is still with the court that hears a bail application to decide what the interest of justice is. I know, my lady, it was submitted by Mr. Isaacs that I don't know who talks about particularizing what the interest of justice is, but I've seen that is absent from the Gustavo case, in that it does not speak in that line that we should particularize. Because my submission will be, how does one particularize something that is difficult to define? Because the court then leaves, rather, the superior courts has left it to the discretion of the court that hears the bail application to consider what is in the interest of justice or the interest of the public, as it is not clearly defined. Whereas Ngipunya says, I think it's paragraph 60, 68 on page 35, where it talks about the prosecution having to particularize what the interest of justice is. But however, the Gustavo case, that does not speak to in the same manner, in that it still leaves the court with the discretion to decide what is in the interest of the public.
Sorry, Mr. Prosecutor, but what I understood Mr. Isaacs also to say is that the magistrate should have indicated what it considered in the interest of justice, because I understood Mr. Isaacs to say that that requirement is necessary for the appellant then to take issue or not issue with those specific reasons given by the magistrate when they wish to appeal. So they should know what the magistrate considered in the interest of justice. And I think that was the critique that you had against this judgment, Mr. Isaacs, if I understood you correctly.
Not only for purpose of bail, but with the commencement, to meet that, to know the appellant what...
Yes, but I understood you to have two issues. Yes. The one is that the state was supposed to give it, and that later on the magistrate was also supposed to at least deal with that matter in the judgment, so that the appellant would know what to attack in future.
That's perfect, Melly.
Thank you.
I want to add a further one, just a B to the A. So what I understand from your argument is that you are saying it was the court's discretion to define that and to make a finding according to the definition that they're giving, considering the circumstances that was placed before the court or the evidence that was placed before court. I want to know, did the court exercise that discretion?
Yes, it did.
The court quo?
Yes, it did.
They did apply that discretion?
Yes.
So if your submission is that they've applied the discretion, do you think that the magistrate correctly balanced the right to liberty against the public interest? And if your answer is in the affirmative, please point me to that part of the ruling.
Yes, the magistrate...
Did that balancing act take place?
On page 4731 of the judgment of the court of court. It's 4731.
Which paragraph?
It's paragraph 113.
You might
Where
proceed.
the magistrate talks about the public interest of the administration of justice. And that's where it starts, but what is of relevance, or where the magistrate emphasizes, is on page 4733, paragraph 115, my apologies, where the magistrate says the case enjoys huge public interest and the allegations against the applicants involve serious charges with substantial amounts of money which were paid to various entities. So I'm saying he took into the account the huge public interest into the matter, the seriousness of the charges, and the substantial amounts of money which were paid to various entities in which some of the applicants and their associates have interest, and some applicants were paid into their personal bank accounts. That's what I'm reading from here.
So that's the definition. According to your submission, the magistrate afforded to the concept of public interest.
Yes, because it's a big concept. It's not defined in a single word. You look at other various factors, just
But
like
those various factors, were they not grounds of objection? Strength of the state's case?
Yes, but then, my lady, I'm saying, is there really a clear definition of the word public interest, which I've stated that
But
even
you
in case
just
of...
submitted that the discretion is left in the hands of the presiding judicial officer to give a definition to what it means before making a conclusion. And that's what I'm asking. I asked, is there any evidence in the ruling that points that the judicial officer has exercised that discretion and has defined what public interest is according to him, in refusing bail? So these are the grounds that you are stating to me. It's paragraph 113 or 4731 and paragraph 4733 of
Paragraph
page
115.
yes, of 115 of page 4733.
Yes.
Okay.
So, my lady, let me state it as follows. Perhaps the court didn't get me. Because the definition of public interest is difficult to define, as I've stated in the cases that I've referred to, Ngipunya and Gustavo, I'm saying, and I've likened it to the concept of substantial and compelling circumstances. It's not cast in stone what that aspect is, the two aspects. But importantly, let me get back to what we are dealing with here. I'm saying the magistrate in his ruling, he looked at the various factors which I'm saying it's the seriousness of the offense, the money that was paid into the personal account, and that the matter enjoys huge public interest. And he came to the conclusion, the court asked if he made a balancing act, and I've stated that sometimes the scales do not balance. But I'm saying in this case, it is evidence from this paragraph that the magistrate took that into account, because it's not defined, but that's what he considered, because the discretion lied with him. And I'm saying he exercised that discretion judicially.
Last one.
Yes.
It's the state that raises the grounds of objection. The state comes and says, I want bail. No, you can't get bail because I'm objecting bail based on these grounds. And one of the grounds is that it's not in the interest of the public or the administration of justice to grant bail without defining what that ground entails, what it means the court must consider under that ground to come to a decision or to use that ground as a reason to refuse bail. The question that I have is the responsibility of a presiding officer in a matter is that he needs to be presented with evidence from both sides, with submissions from both sides, to indicate their different cases, and then based on what is submitted, they must make a definitive ruling, especially in the circumstances of bail where you have the presumption of innocence and you have the right to liberty at stake, which are constitutional concepts that you have. For the state to blanketly throw this ground of objection and say, well, judicial officer, this is the information I'm giving you. When you are done, define for us my ground of objection from what I'm giving you. Is that the correct approach?
My lady, the difficulty that is there is that I've referred the court to two cases.
Yes.
Tengipunya and Gustavo. Unfortunately, it cannot be left to, if the court or our superior courts are unable to define what public interest is because there is no clear definition. It cannot therefore be the duty of the state to define that, because the case law states it's in the discretion of the magistrate. So what if, and it's a submission, it's not a question to court.
Okay.
What if the prosecutor then says, these are the aspects that we consider that are in the interest of the public, and the court then disagrees and says, well, I've looked at your reasons or your grounds, but I do not find them to be in the interest of justice. You see, that's what creates the problem, because it's not a concept that is clearly defined. Because one might define it in their own wording or in their own way. The court before which you appear might define it in their own way. So the conclusion of my argument, yes.
If you choose as a prosecutor to
Yes.
put that forward as a ground
Yes.
of opposition, you, and again, you must have something in mind when you use that ground of opposition. So at least you already formulated some type of concept when you put it forward. Otherwise, it's just a blanket thing that you put forward. So if you put it forward, there must at least be an idea of what you want to convey under this ground of opposition, and you will then steer your evidence that you lead in support of that idea that you have. I agree it is eventually the decision of the court, but at least when you put that forward, you had some idea in your mind why you are putting it forward. Otherwise, it's just like just adding something to the pot without a purpose. So the question is that should you not at least, and I think that is the other part of the objection or the argument that Mr.
None of the legal representatives of the appellants actually raised concern with the fact that we did not define. It was not there. I think that what was there is the attack on the charges. So I understand the concern of the court, but then if an accused is legally represented, as was in the present case, if counsel at that time was of the view that the prosecution did not put grounds that tie with the interests of the public or administration of justice. Was there no duty on counsel then to say, well, it's too vague, you need to define what it is, what is not in the interest of the public? Because we are saying from the reasoning of the magistrate here, the fact that he said it's an economic crime, it's a serious crime, the money was paid into the personal bank accounts, it's public money. Those aspects combined together are what, in our view, constitute interest of the public. And also him saying that it's not public opinion. He said that the public has got an interest in the case. It's not public opinion. So we are saying those factors cumulatively, we are saying the magistrate considered them.
So you say, if I understand you correctly, the answer to Mr. Isaac's argument is that it was never raised that the prosecutors should flesh it out.
It was never raised. I have not seen it, not on page 1, not anywhere on the page, on the record rather.
Thank you.
Yes. My ladies, I think that will be the short of our submissions, or the long of it. We still stand by our prayer in the last part of it that the magistrate exercise his discretion judicially when he denied bail to the appellants, and that decision was not wrong. The court should look at the provisions of section 65(4), and unless it finds that that decision was wrong, then only then will it substitute that decision with one that the court would deem fit. Those will be our submissions as the court pleases.
Thank you. We will now, Mr. Namanji.
Mr. Namanje, before you address us, there's an aspect I want you to address us on. It's a critical aspect.
Yes, my lady.
It's the issue of the bias. And I want to tie it with the fact that what the magistrate did, it was the argument, I'm going to just paraphrase, was fueled by media. And the reference was also made to the fact that the presiding judicial officer referred to the matter as an rot.
Sure, rot.
When we come back, please address us on that one. Or will you do it now? It literally said that the presiding judicial officer was influenced by the media to decide this case. There was a hype up, and that hype up, he was consumed by it. I paraphrase, but that's what the argument was. He did not apply his independent mind to the circumstances that was presented to him.
Let me just ask, is the idea to adjourn now or to continue?
No, we're asking you. Would you like to address us now, or shall we take a break and
Perhaps
then come back?
Break.
Okay.
Yes.
The court stands down, and I think we stand down till 2 o'clock. Then we will hear you. So we break for half an hour, and then we will continue, and then we will hear the replies. Thank you.